This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click the Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Hello, everyone. Thank you for joining us today. My name is Hayward Cho, and I am the General Manager of ADR Services, Inc. Today's program is titled Supercharging and Maximizing Settlements, Unleashing the Power of Expert Collaboration and Expert Insights in Mediation and Beyond. And this will be presented by 3 wonderful speakers, Dr. Azadeh Farron, Stacy Hausner, and Bob Simon. All right, please allow me to first introduce Stacy Hausner, who will then introduce the other panelists. Stacy Hausner has been a full-time mediator with ADR Services, Inc. for the last 7 years. She has an exceptionally high settlement rate and has mediated more than 1,000 disputes in the areas of business, personal injury, employment, real estate, insurance coverage, construction defect, and intellectual property law. Stacy has an LLM in dispute resolution from the Strauss Institute at Pepperdine University School of Law. And when she's not mediating, she teaches mediation theory and practice and advanced mediation at the Strauss Institute at Pepperdine School of Law. She also spends time training mediators for the Central District Court panel, which she just came from, and mediating the litigated case program at Strauss as well. So Stacy, all yours.
All right. Well, thank you for that introduction. Good afternoon, everyone. I am honored and humbled to be a part of this esteemed panel. I want to thank you all for taking time out of your day to join us as we discuss how lawyers can utilize experts in a way to maximize their settlement outcomes. I love this title. It's Supercharging and Maximizing Settlements, Unleashing the Power of Expert Collaboration and Expert Insights in Mediation and Beyond. And my colleague, Myra Fornos, who can't be with us today, she put together this great panel. She chose the title. I love it. And I know it wasn't easy to get these panelists. They are very, very busy in their own practices. So without further ado, thank you both for coming today. I'd like to introduce you. Robert Simon, Bob, is a co-founder of the Simon Law Group, also known as the Justice Team. Since launching the firm with his twin brother when he was only 29 years old, they've grown the firm from a boutique office with just a few people into a 9-figure annual practice recognized by its peers throughout the country, with offices in California, Arizona, and Texas. Bob is known for getting massive verdicts on spine injury cases. He's won Trial Lawyer of the Year several times, very impressive, in San Diego, LA, Orange County, state of California. He regularly educates other lawyers and he frequently publishes various trial lawyer magazines. Since 2012, he's tried over 60 cases as a lead, and he has won 47 of them. 2 were overturned. With verdicts and settlements totaling over $100 million annually. Bob can be heard also on podcasts. He has 3 of them. Bob's truly a forefront in innovation, efficiency, and all things personal injury law. So it is such an honor and pleasure to have you here with us today. We also are very lucky to have Dr. Azadeh Farron. She's a fellowship trained and board certified neurosurgeon at Farron Neurosurgery with experience in a wide range of neurosurgical procedures. She is among only 200 female neurosurgeons in the United States. She graduated high school valedictorian and attended Yale University, where she double majored in molecular biophysics and biochemistry and economics. She earned her MD from UC San Diego, where she won the Whipple Memorial Endowed Scholarship. Her research continued at Columbia University, where she investigated brain tumor growth patterns and established a model for anti-tumor drugs. She has authored several manuscripts manuscripts published in prominent medical journals, excuse me. She completed her internship in general surgery and residency in neurosurgery at USC. She's the first woman in over 25 years to graduate from USC neurosurgery. She's a clinical instructor of neurosurgery at Keck School of Medicine at USC and LA County USC Medical Center. She completed a fellowship in complex spine surgery and spinal deformity tumors at UCSF, receiving the Congress of Neurological Surgeons Spine Research Award. She also has a patent for her spinal device invention. And very excitingly, she also has been a consultant for Grey's Anatomy, for all you Grey's Anatomy fans out there. So both of you, incredible resumes. Thank you for coming today. I wanted to start by just saying that Dr. Farron, and I'm sure you know this, but I want to say it anyway, she's not an advocate. She's an expert who renders an objective opinion as it relates to medicine, an area where she has, obviously, as you can tell, very comprehensive and authoritative knowledge. The attorney then, and we have an expert one with us, then uses the power of this objective opinion to maximize settlement and litigation outcomes. So as we talk today casually about maximizing our outcomes, let's just keep in mind that Dr. Farron is rendering an objective opinion. All right, so lawyers, we are accustomed to using experts in cases to support the various elements of your claims, support defenses, damages, etc. And I have a general mediation practice, so I see a whole variety of experts in these cases and used effectively in these cases. Expert opinions certainly play a role in our mediations, even though the experts rarely appear themselves. Oftentimes, lawyers will convey expert opinions to influence the other side, and they don't bring them into the mediation because of cost considerations in doing so. But regardless of whether they're physically present, the expert opinions, when they're given clearly and convincingly by a qualified expert, they can have a significant impact on the outcome of mediations. So today, our seasoned panelists are going to discuss how and when to use expert testimony most effectively in a mediation so that you can enhance your settlement outcomes. So let's get started here. And Bob, I want to start with you, if that's okay. And generally speaking, can you tell us what type of experts do you typically retain in your accident cases? And does that vary depending if it's on a smaller injury case and a larger injury case? So if you could give us some guidance in that regard, that would be helpful.
Yeah, I'm usually of the mindset that less is more for expert work. I usually rely a lot on the treaters, videotape depositions that, to win our case before we get there. You can do that under like CCP 2025.620 allows you to do that. But in the cases that we're talking about here today, the type of experts that we lean on are, one, is it a liability case? Are you dealing with a liability issue? Different bucket of experts, and you might have to have them certainly have their input before mediation, and maybe somebody as a consultant there to talk to if issues arise. And the other one is working up your medical damages. So if you're trying to leverage a settlement at a mediation, you have to pretty much let the other side know well ahead of time, at least 2 weeks before they roundtable it, what the economics are and why you're asking for a lot of money. And there's no better way to do that than if you already have your expert, if it's Dr. Farron, if she's the treating surgeon, and you have a call and say, hey, what does the future medical care look like? And you put it on pen to paper for us, do it well enough ahead of time, because you don't want to walk into the mediation the first time the defense lawyer and the person with the money is hearing about all these futures is at the mediation and they've set a lower reserve. It's going to do you no good. So liability, it's usually an accident reconstructionist if there's a dispute. Sometimes a human factors expert, depending on the type of case. I rarely, if ever, will have a biomechanical expert just because the science is the science. And I think it's, I won't use a certain term, but there's certain ways to refute a lot of it, as a lawyer. And then the damages side, it's usually the treaters and then maybe a life care planner if you want to really set forth the future economics and resolve your case.
All right. Thank you for that. Dr. Farron, what types of opinions do you typically give in accident cases, and how have you felt that helpful for attorneys?
I think she froze up, so I'm going to answer
You can answer for her.
Yeah, well, there's a question here from Robert Hester. Says, how do you feel about sharing your retained expert reports from the defense and or mediator when you're nowhere
We're
near?
gonna get into all of that. So if you want to pause on that, let me just take you to our next. And when Dr. Farron can reconnect with service, oh, she's out. So hopefully she'll log back in and get service and we'll get back to her. So let me ask you this, oh, you're back. Okay. Did you hear our question or do you want me to repeat it?
I heard everything Bob Simon said, but I missed your question. Forgive me.
Okay, no worries. What types of opinions do you typically give in accident cases and how have you found it helpful to the attorneys?
So anything related to neurosurgery, specifically my expertise would be anything TBI related, anything spinal cord injury related. So I have the good fortune of taking care of these patients out in the community. I cover a couple of level 2 trauma centers. So when we get that call, 30 minutes to show up, ready to operate. Can you hear me okay?
Yes.
Okay. So I am a neurosurgery ER trauma call doctor. That's one of my many hats. But we get a call that just last week, I got a call that somebody was running up and down the street, stabbing people and the police shot him. So come on over. So, or we get a call of somebody's beaten up with a baseball bat or someone got run over by a car, you name it, 30 minutes to show up. And we rapidly assess them. And again, my specialties being both TBI and spine, we are there to address any emergent issues that need immediate intervention. So it could be an emergency craniotomy, it could be an emergency spine surgery if their spine is dislocated, subluxed, et cetera. And so the question being, what kinds of opinions do I render? Since I have the experience of being there from ground zero when they first show up through the ER via the ambulance, we see them from the very beginning. So what exactly the acute injury was, we see them in the hospital for several days. Those patients who have the most serious of all injuries, how their injuries evolve with the secondary mechanisms that transpire, especially related to severe TBI. The secondary mechanisms can sometimes take a situation that wasn't as bad and make it dramatically worse. And then, of course, we follow them all the way through the rehab. So we are there all along the way. And so we can document, examine, diagnose, point out all the imaging, all the physical exam findings that relate to how this injury changed this human being, both from an intracranial standpoint and a spinal cord injury standpoint.
Okay, well, and very interesting. Thank you for that. Okay, I'm switching to you, Bob. Let's talk about criteria for your experts. When you're selecting an expert, what criteria do you consider? So, the other side's going to attack your expert's credentials as one of the ways of discounting the expert opinion. So how do you guard against that? How do you ensure that the expert has the necessary qualifications, expertise, credibility to strengthen your client's position at mediation and even further into the litigation?
Yeah, so I think, I always think trial backwards. When we're retaining an expert, I have to think, is this person I'm going to be comfortable with testifying on behalf of my client on the stand? And I get pretty granular with that. I look at what type of client do you have, where geographically is the trial. I like my experts to look, talk, and think like the jury they may be testifying in front of them. I do not like it whenever you have a radiologist from Texas coming in that is testifying in LA County. It's like, that doesn't really jive too well. It just depends on the circumstances. I do think that there's an A roster of experts that are just the best of the best. Doesn't matter where they're from, you own it. But there's certain cases that just don't warrant on the plaintiff side. We just can't spend a lot of money because we have to keep into consideration the client's bottom line. I do think it's very advantageous. I think one of the best experts you could use as a plaintiff, if you have a really good radiologist that you can act as just a consultant, you can send them films just with a link. They could take a quick look at them and tell you, is this an injury that warrants surgery on? If it's a spine case, is this traumatic or aggravation pre-existing condition? On a brain injury case, they can see things, give you quick opinions. Again, these aren't necessarily retained experts. These may be just your consultants that you use. So you got to be cost effective with it as well. Like, I see too many attorneys make a big problem with hiring right away. I get brought into a case, got brought in one, the cost already $150,000, and we are 6 months from expert designation. This is an admitted liability case. It's just damages. They've already hired a life care plan that they spent like $25,000, like all these things that you don't need, a biomechanical expert or an accident recon. It's like, you don't need this stuff. Now you're trial committed because you spent so much money. It hurts the client's net. So I think you get what you need. A lot of times, Dr. Farron, treating experts can actually give you the biomechanical testimony, the cost of care testimony, and do it all as a treater and the future prognosis. So I'm a big fan of the treaters more than anything.
All right. So you brought up the timing, and oftentimes lawyers are wondering, when should I retain my expert? Do I do it early? In the big cases, maybe I do make the commitment. One thing it sends to the other side, right? A message that you value this case at a high value if you're going to commit the resources to early expert retention. So I've seen that have some persuasive impact, just the mere retention of them early. But what do you consider when deciding when to retain an expert? And yeah, please.
Yeah, I mean, it's 100%. What is the cost benefit analysis of having it? If you're in a disputed liability case, I think you really have to consider having an accident reconstructionist maybe do off the cuff animation that you may. With accident recons, again, anything they're giving you as a lawyer eventually may not be privileged. You have to keep that in mind. Once you give them that file, there's no more privilege if they're your retained expert. So as a consultant, you could do stuff, but you can use the mediation privilege to be educated as a lawyer, show the mediator, who will then explain to the other side, here's what I saw, here's why I think you're in trouble. Now, they won't have access to that animation or recreation, however you want to couch it, until expert discovery, but it allows you to weaponize the go-between your mediator for that conversation.
I like that. Dr. Farron, does it matter to you when you're retained in the litigation? Is it easier when it's early, or does it make any difference on your opinions?
I think Mr. Simon brings up a good point. Sometimes it's not necessary, but for the right case, if we're brought in early, it can definitely help shape discovery. It can lead to a path that may have been unknown or uncharted before. So it depends on how esoteric the area may be. Sometimes having an expert opinion early on from somebody who's credible can force a settlement earlier, brings more gravitas to the matter. So it's on a case-by-case basis. If you have admitted fault, I guess there's no need. But if there's any dispute and you need the weightiness of an expert opinion with a great reputation early on, I think that can potentially force them to go into early settlement. You need a good expert that's not going to gouge you. That's the bottom line. And if we're all here for the same reason, which is to help the patient, help the client, then we're going to do the right thing that's in their best interest.
Right.
Yeah. And to pair it off of that, if this is a causation case, if this is was the spine surgery caused by this, if they had priors or there's something funky in the medicine, the worst thing as a plaintiff lawyer is you're going in there asking for millions of dollars and you have no idea if a doctor is backing up your opinion. Your opinion as a lawyer as to causation. It's the same thing on the other side. When you have an adjuster telling you that there's no mechanism of injury or this is all just pre-existing stuff, I always say, where'd they get that medical degree? Where are they backing it up? So you got to make sure you back up your stuff.
Yeah. What information, Dr. Farron, do you like to have? Or if you are going to be consulted early on, is there anything specific that you need or you don't need to be able to render an opinion?
I like to use the word everything, but basically the complete medical records, because nobody wants to fall flat on their face. You don't want the opposing side having a surprise piece of information, document, medical record that you're not aware of. So the complete medical records from even before the injury, obviously, what were the reasons this patient was seeking medical care with their primary care doctor ahead of time, and then the injury happened. Now, what are they claiming their deficits are? Is that justifiable based on the visits to the doctors, based on the imaging, based on the blood tests, based on their physical exam? So the more complete the record, the more powerful we can be in our position as far as having all the facts that support our position.
All right. This takes us into, we're talking about preparation for the mediation. And oftentimes, when I'm talking to lawyers about optimizing outcomes, I will say, be prepared, right? You need to know the deposition testimony, need to know their legal claims and what their experts are going to say. So you can give us mediators the ammo to push back. So let me ask you this. So Bob, when you're preparing for a mediation where you're relying heavily upon expert testimony, how do you effectively prepare yourself and how do you effectively prepare your experts so that it can have the most persuasive impact on the mediator and on settlement?
Mediators will be impressed if you know the medical records and timelines absolutely cold. A lot of times there's a lot of technology now that helps you. We talk about the use of AI and how it can help you do these things. You saw a lawyer get in trouble using ChatGPT even yesterday in Colorado. I think it's the second ding, but you can use it in this sense, right? There's one company called Even Up that'll be able to do a demand letter for you, the plaintiff, for like $300 or $400, but it also itemizes the medical care costs. You got to know the medical care costs, the economics. If you go to mediation, again, you got to try to see resolve net to the client. The other thing it can do is summarize all of your medical records for you. It can give you a timeline and even tell you what's missing. That's why I love that product. Or you can go and just use just a regular ChatGPT one and drop in the medical records. Well, you can do this with some other programs and ask for a down and dirty timeline. You could do it with, there's a product called Co-Counsel by Case Text, built on legal research platform. You can actually drop in depositions and ask it questions about the depositions if you're that far along. Again, for us, it's a time benefit analysis. We're getting paid perhaps not per hour, so we have to leverage some of this stuff. I use a lot of that stuff to prepare now for mediations and just have a down and dirty stuff. But I like to personally read a lot of the critical medical records. I do a lot of spine injury cases, so I'm reading the MRIs, the records from 3 months. The first 3 months are very critical for me, the surgery reports. And again, if you're going to resolve the case, to be in a position to resolve the case for our side, you have to have the net to the client metrics kind of going down. So we got to know our costs put into it, and we got to know the ability to get down. If we have medical care providers that had delay pay or health insurance that's owed money, we have to have that calculated in.
And do you get that to the mediator before the mediation? Will you call them? Will you get them the timelines? I find timelines are very helpful. What type of information do you get to them before you even get to the mediation?
Yeah, so in our mediation brief, I like to put it again, I like to educate the other side as much as possible. I think it should behoove you to have a conversation with defense counsel well ahead of time to say, hey, if we're going to resolve this, what do you need? What does your adjuster need to see? And then get them that information. And again, if you're writing a letter to the defense lawyer outlining information, I like to get my mediation brief well in advance. Again, ammunition to resolve your case if you want to resolve your case. So timelines are super effective. You're doing your work for the defense lawyer to help you then go give it to the adjuster who's going to see that letter to help you get paid. I think it's also beneficial in some circumstances to list similar verdicts, at least have them in your back pocket for negotiation purposes. To, again, weaponize your mediator.
I 100% agree with all of that. And verdicts can have a lot of persuasive impact. And sometimes they also give settlement figures to the defense, and that can be persuasive also. So if you do have this ready to go, that can be very helpful for us mediators. What information do you get to your, Dr. Farron tells us medical records are helpful, that she wants to see them all. Is that your typical practice? And is there anything else that you get them? Do they look at the defense brief, for example? What gets them ready to render the opinion?
For the experts, I think they have to see everything. Like, I think trial backwards, big ammo for me on cross is whenever the other side doesn't give their expert the complete pieces to the puzzle. They don't have the MRI films. They don't have pre-medical records. They don't have a damages witness. Look, if you're going to get in this game, you want to make sure that they have absolutely every building block to give their testimony. A lot of lawyers get lazy and say, well, did your client have any prior injuries that they're shopping me a case? They're like, well, no. Well, how do you know that? Well, they told me. I was like, that's not good enough. Like, they had to see a PCP, a GP, or saw a medical clinic. Go find those records. It might very much help you in this case. So get all those prior medical records is absolutely critical. Ask Dr. Farron, how is she going to give a clinical diagnosis on aggravation of pre-existing condition if she has no prior medical records? It's very difficult.
Absolutely. And these days with electronic medical records, everything is readily available. I mean, unless you're going back, say, 20 years, But one of the other, some of the tools that the lawyers use, we're starting to use in medicine. So we can take mounds and mounds of paper records that are provided to us over, say, over 10 years of someone's care, and we can OCR it, and then we can do a search for keywords, and we can pick up all the keywords that are relevant to this patient's injury. That's sort of a shortcut way to mine through tons and tons of data, but there is no substitute for going through each page of the medical record, highlighting the critical components, making a timeline, making it chronological, and asking yourself questions along the way. Does this make sense that they would have gone here? What's missing? I bet you the lab test is missing, or, you know, just using your common sense medical judgment to make sure that the timeline is sound and reasonable and represents this patient's experience in a convincing manner, persuasive manner for the mediator.
Do you ever call the mediator, and this is for you, Bob, do you ever call the mediator before or get them videos or demonstratives in some way so that going into the mediation, they're ready to go? Or do you typically wait till you get there?
No, I think it's a conversation well ahead of time. I like mediators, especially that have a pre-mediation conference call at the very least. Again, you're arming your mediator with as much information as possible. I like to always have the cell phone number of that mediator in case you have to follow up a lot of the time, or text information, or like, hey, we're in the virtual world. Like if I'm outside shooting hoops and I get a text, hey, I'm coming back in the room, I can go jump back on screen, finish the mediation. So.
This is why everybody wants Zoom mediations now, right? Okay, let's keep moving on. So timing of the mediation. So sometimes cases don't settle because it's just not the right time. More information's needed. People need to get more authority. Let me ask you, when you have a mediation late in the litigation process, does this change how you use your expert? So what if it's after discovery cutoff? And then how does that impact what materials you may share with your expert before you utilize them in a mediation?
I mean, again, it's cost benefit analysis. If you think a case is going to resolve a mediation, you need a few hurdles to get over, just off the cuff opinions. You're not going to do a full blown, hey, accident recon, do a recreation, inspect both vehicles, do X, Y, Z. You might not need that. If you're mediating a case, if you're at the point where you're doing expert discovery, I still think you got to get all of your expert. If you're at that critical moment, you got to get them everything. It's just, that's the timelining, and you're on a shorter fuse. That's just where you are. I think you should. A lot of times I know the state of the evidence before expert designation. Again, I've already taken the treater depositions. I've already been able to do plug and play and that kind of stuff. But it's all the timeline, use what you need. Like I just resolved a big wrongful death case on the East Coast. We went and there was a big liability dispute. I had my investigator out there. I had a recon. I had a verdict videos go out and do a whole damages piece and then add in all the liability pieces why we won. And we got to them well ahead of time. And I know Edwin Hong, who I think is listening, is one of our partners at the firm. He was able to get it over to them in enough time and actually track how many times they reviewed that video. And it's very powerful to see that shit was watched like 200 times. They were analyzing it like, oh boy, but we had enough time to be able to resolve that case. So
interesting. I like that. Okay, Dr. Farron, have you noticed whether your opinions are more impactful when a mediation occurs early in the litigation process or later? So do you see any differentiation there based on the timing of the mediation?
I would say so. If the mediation is occurring earlier, then our opinions seem to carry more weight because it's just a larger piece of what's being considered to reach the final conclusion. And one of the other benefits of getting your experts involved early for the right case is sometimes they will point out things that you may not know, you may not realize as an attorney, or the patient may not realize. So we are all scientists. We're all about causation. P implies Q. That's how we run our lives as physicians and how we manage patients. And so whatever deficits this patient is experiencing, we're always looking for a justification scientifically. And I think that's one major benefit of bringing the expert in early. If there's any question, if it's unclear, it's a perfect time to bring in an expert. And again, hopefully somebody who's respectful to the patient and not going to gouge them with their fees.
And have you found that later in the litigation, you're looking at different materials? So are you getting litigation materials And does that impact you in any way? Do you like it? Do you not like it? How do you use it?
Absolutely. More records seem to pop up, especially from the other side. The other thing that happens is we get expert testimony from the other side too. So that ends up percolating in as the process lengthens and extends. So it does become potentially a little bit more colorful, potentially a little bit more complicated. You're getting more inputs, but all the more reason to have your expert early where warranted, because they can point out all the salient gems in the physical exam, on the MRI findings, on the CT findings, on the patient's physical exam in the trauma bay, for example, that all support the direction that the attorney is heading.
All right. And do either of you have any tips or stories, specific stories about an experience you've had where you've worked with your expert and been able to make it very effective in the mediation or in the litigation? So that way, where you have like an effective integration of opinions and analysis into the overall case strategy.
Yeah, I think usually in those liability cases where the other side was always just blowing smoke, and we actually had real, as Dr. Farron says, real data and science behind it. We're able to show, like, we've already done the work. Here's our experts saying, show the animation to the mediator and show all the opinions that goes into it. Like, I've done an animation where it's like, we show where the foundation comes from. Police officer gave area of impact here. And you know how impressive that is when you go to the other side. I was like, holy shit, they just proved their liability case. No, we're not getting smoke blown up our butt. This is actual real stuff. I had a big Caltrans death case, and we used a lot of that stuff to win the case in mediation, to show why the value should have been 1 million, should have been closer to 10.
All right. And Dr. Farron, do you have any specific anecdotes where you?
I do. Two come to mind. I had a gentleman, a professor actually, with severe degenerative changes of the spine, and then he had a fall, and then he was newly symptomatic. And the question was, well, you know, he had these severe degenerative findings before, severe stenosis on his MRI before the injury. Why is it that now we're supposed to believe the accident caused these new symptoms? And, you know, this was one example where paying close attention to the MRI pattern, the T2 flare signal, the snake eye signal, as we say, really could distinguish what findings were degenerative and chronic and had nothing to do with the accident, and what findings were clearly accident related and trauma related. So it's taking a fine look at the black and white evidence, and that's the imaging. And in many cases, the imaging can distinguish between chronic findings and acute post-traumatic findings. So that was the key there. We had another patient where I was the expert, and they actually won a large settlement, over $10 million, on a traumatic brain injury case. And the challenge in this case was that the patient had prior brain surgery 20 years before. And there was a consequence from that brain surgery, no question, but it was a known and expected consequence, had nothing to do with traumatic brain injury. Yet one could easily get confused and say, well, you did have brain surgery. There was an issue there, and that's really why you are the way you are. You can't really prove it's the accident. But again, using a fine-tooth comb, using diagrams, simple facts, clear, concise language, you can show very clearly, to the point where even my 9-year-old son understood what deficits are expected from that type of a craniotomy, and what deficits are expected from a traumatic brain injury. And those deficits are miles away. They don't overlap, they're not similar. And using some basic neuroanatomy, some basic logic, we were able to convince the jury.
That's fantastic. All right. Thank you for that. Okay. At the mediation, so Bob, in your experience, what strategies have you found most effective in presenting expert testimony during a mediation? So do you have your experts attend? Are they available on the phone? How do you ensure that your mediator can understand your expert opinions?
So I think it is never a good idea, if you're going to have a retained expert, someone that's going to testify later, attend the mediation. That opens a can of worms, that there's all kind of privilege issues. And just for me, optically, a trial, if I show that the mediator was there trying to I mean, how biased does it look if somebody's at a mediation trying to help one side win physically at the mediation? You could do it as a consultant. You can have somebody on the line on standby to ask questions. I like to have some opinions or some information readily available to me to share on Zoom, just with the mediator to show these are our positions. I also think it's very valuable if you do have deposition testimony already that supports it. I like to have those ready to go, like literally show the evidence, not blown smoke. Here's the actual evidence from what the treater said about causation, about futures, etc. Here's what the officer said about where they found certain evidence. I have that ready to go. But I think that's all just a preparation that you should always have.
Mhm. Okay, Dr. Farron, have you ever been in the mediation or spoken to a mediator? And if so, how did that go?
Nope, not directly, but I know that my opinions were included, in written form or as a video testimony as needed, if needed at the right time, if that time would arise. So like Bob Simon said, on standby if needed.
Okay. Now, let's go to challenges. Can both of you discuss any challenges or obstacles you've encountered when working with experts in mediation? So for you, Dr. Farron, being an expert in mediation, any horror stories that you can share with our listeners so that they can avoid making the same mistake?
I don't really have any, to be honest with you. I mean, most of the experts I've met were very well versed in the medical literature. We all have great track records. The ones that I interact with, I mean, we've all read the medical record. We know it backward and forward. We can recite the date, the time, the place where the scan occurred, the findings on the scan by heart. So I really haven't had a nightmare. I mean, I've never had a problem with records not being provided. I think all in all, the environment has been pretty favorable and made it relatively straightforward to provide an objective opinion. Now, again, I think the issue is that to remember that we are an expert, we are there to represent the truth. And so our jobs are made easy when we're provided the truth, which is the medical record, and not deviating from that. And obviously staying close to the Holy Bible, which is the medical record, and respecting that, that's gonna win the case.
Bob, you have any stories when you were just starting out? Any mistakes you made that you can share with us so that other lawyers don't fall into that some sort of trap?
I think the biggest mistake is just not being prepared or knowing your file. And a lot of times on our side, we're having a mediation within a mediation. We've not prepared our client on what to expect, not prepared our client on what's going on or expectations. You should have that. It's a whole separate webinar on preparation for your client and expectations and managing thereof. I think that's the biggest mistake that you can make.
Yeah, and getting them to understand the process and able to actually resolve the case, put it behind them. Timing to when to reveal information at a mediation. So information is power. And I respect that a lot of attorneys, when they come in, they don't really want to tip off their hand or reveal powerful testimony. It could be expert testimony or information, unless they think the case is going to settle, unless the other side has the authority or is coming into a reasonable settlement range. So what are your considerations, Bob, in determining whether to share the expert, when to share it? What type of analysis do you do in that regard?
I think you share it if you think that it's going to help move the needle or get the case resolved. If you walk into a mediation and you hear you're so far apart that it's never going to resolve, why would you share that critical piece of information if it's not going to move the needle? Then you just use the mediation as an education learning tool. I see it as an investment in your case to pay for the mediation to get the other side's information. As somebody says, I was on a podcast with Ryan Cogger and Craig Hartzyker, and he was like, this is the only place in the world where everybody knows the value of the house is $1 million. Everybody knows the value is $1 million. One side starts at 10 million and one starts at 25,000. It's like, it makes no logical sense. But if they're at 700 and you're at 3 million, that you have a chance to get the case done at 1 million, then it's time to maybe show your ace in the hole to get the case resolved.
So you typically now, do you tell your mediator, look, here's what I have, but don't share it? Do you hold it and just wait to see if they're getting into the range you like? I mean, do you have a typical standard of practice in this regard, or do you just kind of get the feel of it when you get there?
You know when you know. It's like that old adage about whether it's art or not, you know when you know. You know when you're close.
All right, sounds good. Okay, battling of the experts. So we know that the opposing party is going to have expert opinions too, and they're typically contrary to the expert opinions you're rendering. How do you navigate differing in expert opinions? I'm first going to ask you, Bob, and then I'm going to talk to you about this, Dr. Farron. How do you navigate differing expert opinions, leverage your own experts to achieve a favorable settlement outcome? Do you handle situations where opposing party challenges the credibility or qualifications of your expert witnesses during the mediation? Do you handle that differently? How do you handle that? And what steps do you take to defend and uphold the integrity of your experts?
I mean, hopefully that on my end, again, trying a lot of spine injury cases or doing a lot of product cases, you've hired the right people. I mean, I always look at, I know our networks, I know who I use in trial, but I also see if it's a product case who's successfully testified on those cases, check their credentials. I think in today's world, some jurors are still wowed by credentials, but more people are wowed by their experience and how they testify. Some of the best people in product cases don't even have a college education. They're just expert motorcycle riders and handlers and build them and things like this. I don't think that's too much fleshed out in the mediation stage, more the expert discovery thing. But I know if I know who the defense hired to do their black box download or look at the scene, if that's a really shitty expert, it allows me in the mediation to tell the mediator, this person is a joke. This is all the stuff I know about them. Maybe that helps you resolve the case.
And I've seen the impact of this as a mediator. I have on one side, the orthopedist for the Olympic team. And on the other side, you have somebody who is not even practicing medicine anymore and is a regularly retained defense expert. That does seem to have some impact and some persuasion in helping to achieve a settlement. So do you get into a battle of expert opinion? So if you're sharing with the mediator, my expert is saying this about this, and they come back at you and push on their expert, how much do you engage in the nuance of it? At that point, are you calling your expert to get their take on why there's the variance in opinion? How do you handle that situation?
If it's brand new information, like something I didn't think of, then it reserves a text or a call to my expert to say, hey, they're saying this. What do you think about that? Or if it's something totally out of left field. But a lot of times I just say, if they say all this other stuff, I said, can you ask me to have their experts send me that opinion to a reasonable degree of medical probability? Then we'll talk. This is all just fluff. You could tell when it's somebody just talking to talk. But a lot of times, again, if you get to mediation and the defense did their defense medical exam already, you should have that pulled up and ready to show the mediator the concessions or findings that may be adverse to what the defense lawyer is already saying. Or it also is helpful if you know the general testimony of that expert from other cases to show the mediator this is what they're likely going to say on the future medical care costs. This is how they talk about causation. This is why we're going to win this case.
And who do you send to the medical exam?
Okay, practice point. Never, ever do it as a lawyer. If you're a lawyer, you may become a witness. A lot of lawyers say, I'll go to the medical exam. I say, well, what if you have to go testify because of something that you saw? I always like to send a nurse. There's companies that do those. Juries love nurses, not so much lawyers. Nurses, very high credibility, lawyers, very low. So if you get a nurse there recording and they're saying that the doctor did something different than what they said they did in the report, and they have audio on it, that goes a long way. So I always send a nurse observer.
With audio recording.
With audio recording.
And taking notes.
Yeah, then they usually send, if they have notes that could be, it's still privileged. They usually send me a report of everything that they saw and some observations and things like that.
Okay. So Dr. Farron, have you had an experience with this where you're kind of in a battle of the experts, where the other side's challenging your opinions or your qualifications, And if so, what strategies do you employ to clearly communicate medical concepts and terminology? How can attorneys help you so that you're armed with what you need to give your objective opinion?
Well, thank you. Again, it's the medical records and all the facts, and hopefully you have a patient who's credible and interviews, tells you the truth, and isn't fabricating. And if you have that, you're golden. So as personally, I've never had my credibility attacked. I've been very fortunate. I've been in practice for 13 years. I've never had a lawsuit. The average in neurosurgery is a lawsuit every couple of years. I'm board certified, pretty clean record. So fortunately, I've never had the misfortune of being attacked on my record. And then I would say the other advantage I have is I won't take a case that's shady. I'm going to take a case where the facts support the patient's presentation and everything is in alignment. So I can take a case like that and bring it to closure because the facts are all in alignment with the patient's story, their injuries, it's all congruent. But anything that's being jerry-rigged or just sort of thrown together where the facts don't support what their direction they're trying to go, I would never take a case like that. So I think it's sticking to the facts, sticking to your discipline, staying in your lane. We all know what's appropriate neurosurgically. We all know what standard of care is. We all know about causation, what kind of injuries can cause, what kind of neurologic deficits, and being true to that, you're going to convince the world.
So do you have any stories for us where you've rendered an opinion and the other side has an opposite opinion, and how you were able to clearly convince a mediator or the other side in settlement or in litigation as to your opinion?
The biggest case that comes to mind is the one where the patient had a pre-existing neurologic deficit and then suffered a head injury. And there was quite a bit of back and forth from the defense side about, well, she was already seen for headaches by her doctor before the traumatic event, before she was rear-ended. She already went to the doctor for headaches and she already had this neurologic deficit. But again, you don't need an audience of Einsteins to be able to explain the truth. And sometimes you do have to split some hairs, but if you use common sense and logic and explain why one factor can lead to one sort of injury and another factor leads to a traumatic brain injury, which is very distinct from the pre-existing scenario, using very simple but clear neuroanatomic tools, then you'll be undefeated. I've never had a challenge where I wasn't successful in that regard.
All right. Okay, Bob, you had mentioned earlier undesignated experts, and let's talk about that a little bit. How you can use undesignated experts to your advantage. Do you bring them in to a mediation, test their theories? If they can't deal with pushback, then they don't become your retained expert. Is it work product? Do you ever get pushback on that? Tell us about that.
So I think, a good consultant, like product cases, sometimes it's my buddy, like literally just builds race cars. So I get opinions from him. He'll never be an expert, but he tells me the real stuff that's not that expensive for him to tell me. And I load it up with all this wealth of information. The radiology example I mentioned, like these people are remote, they're in other states. They'll never be used as a testifying expert, but I'll send them a bunch of film. It's very powerful in these cases when they can actually go on the MRI and circle things. And I can show the MRI mediation and say, look, madam mediator, that's compression, right? Like you could see this big disc right here. That's an extrusion. It's circling it and measuring it, doing those things. It's a very powerful tool. I think those are two of the most inexpensive people that you can use for lower price point opinions.
That's great. Okay. And expert costs, you ever try to recover those in settlement? Or do you just kind of in your mind keep track of what the costs are and then you just inflate your demand by that amount?
Wait, say it again. Inflated by how much?
Do you ever specifically ask the other side to pay for your expert costs and say, look, I need 100,000 because I put this on experts?
Well,
or do you just kind of
the only rare time I do something like that is whenever it was obvious the delay tactic by the defense, and we had to waste so much money on something that was so obvious, and I had to overspend on experts and say, look, the reason we're here is because I can't resolve this case because you made us spend all this stuff. If you would listen to your expert, we would have never been here. So this is why we're demanding a premium on it. Now, the realistic point of view is that that's never going to move the needle for the adjuster. They're not going to pay you an extra $100,000 because you spent an extra $100,000. It might work though on 998 costs because you can show when you made that 998. Another great tool for the mediators. Like, look at the time we made our demand. Here's how much time we spent since then. We're going to take this to verdict. So even if I win $200,000, guess what? That means that's another $200,000 swing. So that's a very powerful negotiation tool too.
Great. That's helpful. Okay, so I wanted to save any closing remarks by the two of you, and then I want to get to some questions that our audience has. So if you is there anything else you want to add before we take some questions?
No, I just want to impress again from you have to educate the other side. I try to do at least 30 days, calendar it, have an automated calendar over 30 days. Call the defense, see what they need, or send them extra information so you're not wasting everybody.
And I will agree with that because you want to get the other side to give you what you're asking for. So you need, in his situation, you need as much authority as you can. So the more you're just helping your case by giving them time to really evaluate it similarly to how you evaluate it. So I think from a mediator's perspective, I see the impact of that. What about you, Dr. Farron?
I would just say, get in there at the right time with the right information. It doesn't hurt to, we could call it a curbside consult in medicine. If you've got some questions and you want to run it by me or any of your expert friends, it doesn't hurt to just get a very casual look at this and decide if if a deeper dive would be beneficial and at this time point or not. But just to do a smell test and to see, does this have warrant to move forward in this direction or not? So I'm certainly more than happy to look at something preliminarily and provide some guidance and determine whether our involvement early on or later on would be helpful and whether the case has merit based on initial facts.
Okay, so thank you for that, both of you. I wanted to choose, we only have a few minutes left, but let me just get to some of the questions. One is, how do you feel about sharing your retained expert reports with the defense or meter when you're nowhere near your deadline to disclose your experts?
I think it's a good idea to do it. If it's a medical report, you know that they have all the information that you need in order for them to give that opinion. The more dynamic things are accident reconstruction, where more facts come and things may change, and you don't want to get married to a animation you did 6 months before trial before you had a lot of information, because that can be used against you in a very severe way. And again, you have the confidential process where you can show it to the mediator who can educate the other side as well, and then you're all good. So that's probably the biggest fail-safe way to do it. I generally do not if they're experts. If they're the treater that outlined a life care plan for future, that's okay because they already put it in writing anyway.
Okay, and I have a question. If you use your expert ahead of or at mediation who shares their file, will then you use another expert at trial?
Well, if they do that, once you disclose somebody's opinion by rule, the privilege no longer exists in the four corners of that document. If they disclose an opinion to you, I've had a situation happen before where they gave me the report of one expert, and then they tried to de-designate that expert the day before the deposition. I then subpoenaed the expert and said, I want to be able to depose them. They tried to quash it. We won, and they had to produce this expert who was giving us advantageous opinions because they already disclosed the opinion. Look, you can pull it back, but as soon as you disclose their opinion, even if it's their report, that privilege doesn't exist anymore. They're no longer that consultant attorney work product. So just be very wary, because a lot of times with the 3-day rule before deposition, our paralegals are told to produce everything ahead of time. If you, the lawyer, is not paying attention, it can be real bad because they could be producing an expert you may not want to have be deposed, and all of a sudden their opinion's out there and you're not looking good.
Stuck. Okay, Dr. Farron, this is for you. How often, if ever, have you changed your medical opinion based on information subsequently provided by opposing counsel?
Fortunately, I've not needed to do that. I tend to look at the data pretty hard and pretty deeply, intensely, before I decide to commit to something, to a certain, before I decide to accept an expert role. So fortunately, I've not been in the position where there have been surprises that have come my way, or new medical records or new information.
Okay, and Bob, this is for you. If you feel you have everything you need from your treaters to prove your case medically, and you've already deposed them, will you not designate a medical?
I will always still designate a third-party retained expert to be able to back up everything that the treater said. They'll be able to give all the same opinions. And since it's coming from two different sources, if it's a neurosurgeon, if it's Dr. Farron, who's a neurosurgeon, then I might have an orthopedic spine surgeon as retained, and then be able to double dip those opinions at trial. Now you have the treater and the expert saying the exact same thing. Yes. So the short answer is yes,
Okay.
but someone different.
Right. Okay, and then it was asked, can you address using expert in cases other than PI or med mal, like employment, civil rights? I have a general practice. I do a lot of PI, but I also do these other types of cases as well. Everything they're saying, applies. It's just different context. So I did an HOA case the other day, and we needed the downstairs neighbor was complaining about the sound of the floors from the upstairs neighbor. So we had an expert for a sound engineer expert. We had a acoustic flooring expert. We had a real estate appraiser, a diminution in value to support that claim of damages. So we had an HOA expert on the regs and the regulations for the HOA. So all cases have them. They are typically, lawyers are using them and saying, this is what my expert will say. My practice pointer there would be, you have a lot more persuasive impact when you have a specific name of an expert who's qualified in the area, and you're giving a specific opinion. So, when you come in and say, I have an expert who's going to say the sound wasn't loud, or I have an expert who's going to say the treating doctors charged too much, that's not going to be as impactful if you have a specific expert who charges much less and is rendering a specific opinion as to what part of the medical billing is inappropriate. So my advice always is, you can have a lot more impact in your use of experts with that type of specificity.
Yeah.
I'm happy to answer specific cases that you may have if you want to reach out to me after this about use of experts. And Hayward's back on, but before he talks, I just want to thank you both so much. We all could learn so much from you today, and I really appreciate, I know you're so busy, so we appreciate you taking the time to talk with us today.
Thank you for having me.
Yeah, so thank you again, speakers, and thank you all for joining us today. As a reminder, your CLE certificates and written materials will be emailed to you after the program. And when I close this program, you will again be directed to a brief survey. We would very much appreciate your feedback on today's presentation. All right, that concludes this program. And until next time, please enjoy the following video.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.